Every single day in America, a family loses their home because mom went into a nursing home, not because they wanted to sell it, because the government forced them to. This video covers every threat to your family's inheritance, from nursing home, seizure, to probate court, to taxes, and exactly what you can do about each one. Let me walk you through what's really at stake. When someone enters a nursing home and the national median cost is over $9,700 a month for a private room, more than $116,000 a year, according to the Genworth Cost of Care survey, Medicaid will pay for that care. But here's what nobody tells you. Medicaid estate recovery, that's the government program created by the Omnibus Budget Reconciliation Act of 1993 that requires every state to recover costs from the estates of deceased Medicaid recipients age 55 and older can place a lien on your home and force its sale after you die. A $300,000 home, gone. Your kids get nothing. Now, there are protections. If a surviving spouse still lives in the home, Medicaid cannot touch it while they're alive. But once that spouse also passes away or moves out permanently, the state can come calling, and they do. The Medicaid lookback period, the 5-year window where the government examines every financial move you made before you applied for benefits, means that if you gave your daughter $50,000 3 years ago to help with her mortgage, Medicaid doesn't deny you forever. Instead, they impose a penalty period. The penalty is calculated by dividing that $50,000 by your state's average monthly nursing home cost. If your state's average is $10,000 per month, that gift creates a 5-month penalty where Medicaid won't pay 5 months of paying out of pocket at $10,000 a month. That's $50,000. They treat that gift like you still have the money, you don't. But they count it anyway. And if you no longer have the money to pay privately during that penalty period, you have a crisis on your hands. Then there's probate court, the legal process that freezes your assets for 6 to 24 months after you die. Probate costs 3 to 7% of everything you own, according to the American Bar Association. A $400,000 estate can lose $12,000 to $28,000 just in court fees and attorney costs. And probate is public record. Your neighbor, your cousin, anyone can look up exactly what your kids inherited and what your house sold for. Now let's talk about taxes. The federal estate tax currently applies to estates worth more than the exemption amount. But here's the time bomb. The Tax Cuts and Jobs Act of 2017 doubled that exemption to roughly $13 million per person in 2025. That law was always set to expire at the end of 2025, and unless Congress acts to extend it, the exemption drops roughly in half. That means estates that were safe suddenly aren't. A family farm worth $9 million, a small business, a couple who saved their whole lives, all of them could be dragged into the federal estate tax net when they weren't before. And that's just the federal level. 12 states and the District of Columbia impose their own estate tax. That's a tax on the estate before your kids get anything. Oregon has the lowest threshold at just $1 million. So you could have a $1.5 million estate that owes zero federal tax, but gets hit with a state estate tax bill. Then there's the inheritance tax, and this is different from the estate tax. An estate tax is paid by the estate. An inheritance tax is paid by the person receiving the money. 5 states still collect an inheritance tax: Kentucky, Maryland, Nebraska, New Jersey, and Pennsylvania. In Pennsylvania, your own children pay 4.5%. Siblings pay 12%. Anyone else pays 15%. In Nebraska, non-immediate relatives pay 18%. Maryland is the only state that hits you with both an estate tax and an inheritance tax. Double tap. The step up in cost basis, that's the tax rule that resets the value of your home to its current market price when you die, meaning your kids pay zero capital gains tax when they sell that rule alone. Saves families tens of thousands of dollars. You bought your house in 1988 for $85,000. It's worth $380,000 today. Without step up, your kids would owe capital gains tax on $295,000 of growth. With step up, they owe nothing, zero. But proposals to limit or eliminate step up in basis have appeared in multiple presidential budget proposals over the last several years. If that rule goes away, every family inheriting a home gets a tax bill they weren't expecting. And beneficiary forms. Industry surveys consistently show that roughly 1 in 4 beneficiary forms on retirement accounts contains an error or is outdated, pointing to an ex-spouse or blank, or missing contingent beneficiaries entirely. Here's the part that catches people off guard. If your 401k beneficiary form still names your first wife from 1,992, she gets the money, not your kids, not your current wife. The 1,992 form wins every single time. Beneficiary designations override your will. That's not a theory. That's the law. In every state, financial predators target seniors with the precision of a surgeon. Annuity surrender fees that lock up your life savings for 10 years or more. And if you need the money early, the penalty can be 10% or higher. Power of attorney abuse, where someone you trusted, a caregiver, a family member, a new friend, slowly drains your accounts while you're vulnerable. Reverse mortgage traps that eat your equity month by month while you're still living in the house. And when you pass away, there's nothing left for your kids. Your home equity is the biggest target. Property tax liens can be placed on your home if you fall behind on taxes. Medical debt liens, contractor liens, a forced sale by heirs who disagree about what to do with the property. And if you added one of your kids to the deed to avoid probate, a mistake millions of families make, you just open the door for that child's creditors, their divorce, their lawsuit to come after your house. Because now that child is a partial owner and their problems become your problems. And here's one most people never think about: your digital life. What happens to your email, your photos, your online bank accounts, your social media when you die? Without a digital estate plan, your kids can be permanently locked out. The Revised Uniform Fiduciary Access to Digital Assets Act, that's the law adopted by most states, as of 2024, gives your executor legal access to your digital accounts, but only if you specifically authorized it in your estate planning documents or in the platform's own settings. Most families never set this up. So the accounts sit there unreachable. Money in an online-only bank account that no one can access. Crypto wallets with passwords no one knows. And then there's the blended family disaster. Studies in estate planning literature suggest that as many as 60% of children from first marriages are accidentally disinherited when a parent remarries. The scenario plays out the same way every time. You leave everything to your second wife. You trust her to take care of your kids. She lives another 15 years. She changes the will. Or she simply outlives the money. Your kids from your first marriage get nothing. Not because you didn't love them, because you didn't put the right walls in place. These threats are real and they are destroying families every day. But there is a complete roadmap for every single one of these problems in the Inheritance Quick Shield Guide. It walks you through each threat, step by step. The quick fixes you can do this afternoon and the bigger strategies that need planning. Link in the description. Now, here's what you can actually do. Let's start with the biggest one, the nursing home. An irrevocable trust, sometimes called an irrevocable Medicaid trust or a Medicaid asset protection trust, removes your home from your name. You transfer the house into the trust. Once it's in there, Medicaid cannot touch it because you no longer own it. The trust does. The catch, you have to do this at least 5 years before you need nursing home care. That look back period I mentioned, this is how you beat it. Start the clock now. If you're healthy today, every month you wait is one more month of vulnerability. You can still live in the house. You just can't sell it or refinance it without the trustee's involvement. And you cannot change your mind and take it back. That's the trade-off. Protection in exchange for control. The Community Spouse Resource Allowance. That's the federal rule that lets the healthy spouse keep up to $154,140 in countable assets as of 2025 adjusted annually. While the other spouse qualifies for Medicaid, most families never hear about this. Without it, the healthy spouse could be left with as little as about $30,000 in some states. A Medicaid annuity, a specific type of annuity that converts countable assets into an exempt income stream for the healthy spouse, can protect additional money while still qualifying for benefits. This is not a do-it-yourself strategy, but it exists, and it saves families hundreds of thousands of dollars every year. For probate, you have 3 tools that bypass the court entirely. A revocable living trust. You put your assets in the trust while you're alive. You control everything as the trustee. And when you die, your successor trustee distributes everything to your kids without court involvement. No judge, no public record, no 6-month wait. A transfer on death deed available in over 30 states plus the District of Columbia. Free to file in most jurisdictions, takes 15 minutes to fill out your home, goes directly to your named beneficiary. Payable on death accounts, you add a beneficiary to your bank account or certificate of deposit in about 10 minutes at your bank. Done, no probate. For taxes, the step up in cost basis is your best friend. If you bought your home for $85,000 and it's worth $400,000 when you die, your kid's tax basis becomes $400,000. They sell it for $400,000 and pay zero capital gains tax. Zero. That's roughly $47,500 in capital gains tax that your family never owes. That savings disappears if Congress eliminates step up. The annual gift exclusion, $19,000 per person per year as of 2025. $38,000 per couple lets you move money to your family without filing a single gift tax return. 2 kids, a married couple, that's $76,000 per year. Over 10 years, that's $760,000 transferred to your children completely tax-free. No loophole, no attorney, no forms beyond the normal bank transfer. That is the law. Chapter 1 of the Inheritance Quick Shield Guide walks you through the transfer on death deed with the exact form and step-by-step filing instructions for your state. Chapter 2 has the beneficiary audit checklist, 1 page. Fill it out this afternoon and catch the mistakes that accidentally disinherit your kids. Both links are in the description. Here's where most people get it wrong and where the real money is lost or saved. A revocable living trust avoids probate, but it does absolutely nothing to protect against Medicaid. Zero. A lot of families pay $2,000 or $3,000 for a revocable trust thinking it shields their home from nursing home costs. It doesn't. The government considers assets in a revocable trust as still yours because you can take them back anytime. An irrevocable trust does protect against Medicaid because you gave up control. But you gave up control, you can't change your mind and take the house back. So the question becomes, are you willing to lock the door and throw away the key? Because that's what an irrevocable trust does for your home. Here's a connection almost nobody makes. Your Social Security claiming decision directly affects what your kids inherit. If you claim at 62 instead of waiting until 70, you're not just reducing your monthly check by up to 30%, you're destroying the survivor benefit your spouse gets after you die. The survivor benefit is based on the higher earner's benefit amount. Claim early, and that amount is permanently reduced. The difference between claiming at 62 and 70 can mean your surviving spouse receives over $1,000 less per month. That's more than $12,000 a year for the rest of their life. Over a 20-year widowhood, that's potentially $250,000 your family loses. And when your spouse is struggling financially, your kids step in to help. That money comes out of their pockets. Delayed retirement credits the 8% per year increase for waiting past full retirement age, which is 67. For anyone born in 1960 or later, don't just benefit you. They're an inheritance strategy. Every year you wait, your benefit grows by 8%. Your survivor benefit grows by the same amount. Your kids inherit more because your spouse isn't struggling. And the blended family disaster. Studies suggest as many as 60% of children from first marriages are accidentally disinherited when a parent remarries. You leave everything to your second wife. She lives another 15 years, she changes the will, or she simply spends down the assets. Your kids from your first marriage get nothing. A Q-tip trust, qualified terminable interest property trust, solves this. Your second wife receives income from the trust for her lifetime, but the principal goes to your kids when she dies. She can't redirect it. She can't change the beneficiaries. The trust controls where the money ends up. The life estate deed does the same thing for your home. Roughly a $200 document that guarantees your kids inherit the house no matter what your second spouse does later. And for veterans, if you or your spouse served during a period of wartime, even if you never left the country, even if you never saw combat, VA Aid and Attendance provides a monthly benefit. In 2025, a veteran with no dependents can receive up to approximately $2,300 per month. A surviving spouse can receive up to approximately $1,478 per month. That money pays for in-home care or assisted living, which keeps families from selling the house to cover those costs. Most veterans have no idea this exists. The application is VA Form 21P 527EZ. Look it up. Long-term care insurance. The brutal math, the average nursing home stay is 2.5 years at nearly $10,000 a month. That's close to $300,000. Traditional long-term care insurance premiums have skyrocketed. Some policyholders have seen rate increases of 50% or more. Hybrid policies that combine life insurance with a long-term care rider are becoming the better option for many families, because if you never need care, your kids still get the death benefit. State partnership programs exist in most states by a qualifying LTC policy, and the state protects assets above the policy's coverage limit from Medicaid recovery. That's a direct shield for your home equity. And the Ladybird deed, also called an enhanced life estate deed, available in a handful of states including Florida, Texas, and Michigan. This is the best of both worlds. You keep full control of your home during your lifetime. You can sell it, mortgage it, or change your mind. But when you die, the property automatically transfers to your named beneficiary without probate. No irrevocable trust needed. No giving up control. Not available in every state, but if yours is one of them, this is one of the simplest and most powerful tools in the entire inheritance protection toolkit. And don't forget about the federal estate tax exemption. If the doubled exemption from the 2017 tax law is not extended by Congress, it's scheduled to drop roughly in half. For a married couple, that means the protected amount could fall from around $28 million down to around $14 million. That sounds like it only affects the ultra wealthy, but consider this: a family business, a farm, a couple who owns investment property plus their home, combine all of that, and you'd be surprised how fast the numbers add up. Anyone with a combined estate over $7 million per person needs to be paying close attention to what Congress does. 5 things to do today. 1, pull out every beneficiary form for every account you own. IRAs, 401 KECs, life insurance, bank accounts, annuities. Check the names. Check the contingent beneficiaries. If they're wrong or blank, fix them this week. This takes 30 minutes, and it's the single most common way families get blindsided. 2, find out if your state offers a transfer on death deed. Over 30 states, plus DC do. If yours is one of them, fill it out and file it. Your home skips probate entirely. No attorney needed in most states. 3, if you or your spouse served during wartime, even if you never left the country, look into VA aid and attendance. VA Form 21P 527EZ. The benefit pays up to approximately $2,300 per month for a veteran. That money can be the difference between keeping the house and losing it. 4, check if your state has an estate tax or inheritance tax. 12 states plus DC have an estate tax with thresholds as low as $1 million. 5 states have an inheritance tax. Know what you're facing so there are no surprises. 5, if you're married and your combined assets are anywhere near $7 million, talk to an estate planning attorney now, not later, about the federal exemption. If that exemption drops, the window to use it closes. Once it's gone, strategies that are available today won't be available tomorrow. Don't wait for a crisis to start protecting your family. The Inheritance Quick Shield Guide covers every threat in this video with checklists, forms, and step-by-step instructions. If you need the advanced strategies, the irrevocable trust, the Medicaid Shield, the Tax Fortress, the Family Fortress Blueprint has those. Both links are below. Your kids are counting on you to get this right.